be seated. I'm sorry. Pay attention. All right. We got that deposition witness. Did y'all get sorted out what was designated?
We did, Your Honor, and we can rely upon what is designated.
Very well. Now, you have a preliminary objection to the portions of this.
Yes.
Let's put that on the record first. I'll be glad to hear from you.
Very well, Your Honor. I filed a motion to limit the secret to exclude portions, all the portions of this witness's deposition testimony. Primarily what I seek is some of the opinions he's given. We do not take any issue with his pedigree, with his credentials. We do not take any issue with his expertise. He, as Mr. Tinley said, he is probably the audio acoustics expert in this field because he's pioneered much of this. And when he's pioneered much of this, he's written extensive papers and he's made elaborate laboratory calculations, none of which were done in this case. In this case, he listened to an audio recording from several thousand miles away, and he made some opinions. And he made those opinions based on a three-part analysis, which he'll explain. And we have no problems with some of his opinions because they're reasonable, they're reliable. But some, Your Honor, don't make any sense at all. And obviously, cross-examination can bring that out. Obviously, argument can deal with that. But the court does have a gatekeeper role. And under Rule 702 in the case law, the court does have a gatekeeper role to make sure what we're receiving opinions on is reliable. In this case, and we briefed it, it's filed with the court. There's some opinions that he's going to give. First off, he heard so many shots, and I'll testimony for itself, come from within this vehicle. We don't really have a problem with that because he was listening to it, okay? And he's got a spectrogram, he's got a waveform analysis, and it looks like he's probably got the right number. But then he seeks to assign things that aren't unreasonable. For example, he's going to tell you it's likely that so many shots came from one gun before the other shots started. No gun involved in this incident will hold as many shots as he's going to opine to. That's physical evidence. This doctor has said, normally when we hire expert witnesses, we give them data, we give them our records, we give them everything that we can give them that they can rely upon to base their opinion. In this unusual situation, this expert, he refuses to look at anything. He said, all I want to hear is audio. And he even wrote a book on it. He said, I don't want any outside influence over his audio. And then, and I accept that as a reasonable way of coming to his initial opinion. But then to refuse to look at the physical objective data and adjust your opinions as necessary to make common sense, I think is beyond what is admissible under Rule 702 in our case law because it's not reliable. Well, it does go to way, obviously, in argument. But the reality is it doesn't meet the criteria under Rule 702. For him to try to assign from an audio recording guns to one particular, shots to one gun or another, he doesn't even know what kind of guns they are. He doesn't know anything about the proximity of them to each other. He doesn't know anything about the capacity of them. He doesn't know anything about the juxtaposition of the vehicles or orientation. It's unreasonable for him to make that kind of opinion. And so we seek to exclude and ask the court not to consider opinions that don't meet the reliability test because he expressly refused to look at the objective data.
Well, if this were a traditional jury trial, the court could hear the testimony in camera, make that determination before a jury were to hear it. So I got to hear it all at one time, and if I support your argument, then I will not rely upon it in my decision making.
Very good.
Simple enough.
Thank you very much.
It's simple enough to say, maybe difficult to apply.
I understand.
All right, we ready to go?
Yes, sir.
All right. We need to take that board down so people can see from the other side.
I just never took it.
Yeah.
You've been working off of 3, hadn't you? I gave y'all too long for lunch. Am I gonna get Mary Catherine over there?
Might have to do it. Let Morgan do it, Judge. Morgan.
That's
What's up,
probably
man?
enough, his pennies anyway.
Huh?
That's probably enough anyway.
He's enough. You hear one expert for tomorrow? Is that the argument? I heard that work sometimes.
Hold on, Judge, we got on Netflix on the other ones. Work all day.
Mm-hmm.
I'll do anything good.
Guess we shouldn't have taken them up.
No, no, she went right on through.
We'd be going home by now.
I don't know about
This is why I like all this paper.
backup plan. Y'all done an excellent job of tag teaming the electronics. You've done a good job. Very, very professional. Technology's come a long way since I started practicing on. This is a sign. This is a sign, end. Somebody jinxed us.
If y'all don't get this straight, I'm gonna get up.
Warren, you stay right there.
My screen just blank like it always has. It usually works, but nothing can. Let's just watch the next one.
Put Seinfeld on. No soup for you.
Hand slapped off, what do you do?
I mean, we can do that. It's been done before. Sometimes people even call live witnesses.
I would have, because most of Montana.
It's a long walk. They won't know any better. I mean, I got the best two, maybe not.
I got it.
November, I knew that. Oscar. Cynthia, I want that on the record. Mary Catherine is the solution to that problem. We had too many boys on it.
That's, you always need
Randy,
that
you did good
woman's
too.
touch. You need the woman's touch, you know.
Apparently.
A recorded and video conference deposition of Robert C. Maher, PhD, PE, taken in the Court of Common Pleas, 15th Judicial Circuit, State of South Carolina, County of Horry. Case number 2024-CP-26-03798. Jennifer Spivey Foley as personal representative of the estate of Scott Ryan Spivey versus Charles Weldon Boyd and Kenneth Williams. Today is September 8th, 2025. The time is 12:55 p.m. Mountain Time. We are present with the witness at 608 Cobley Hall, Montana State University, Bozeman, Montana 59717. The court reporter is Deb Favorites, and the video operator is Bridger Arthen of Fisher Court Reporting. The deposition is being taken pursuant to notice. I would now ask the attorneys to identify themselves, who they represent, and whoever else is present. For those attending remotely, please note from where you are appearing.
So Mark Tinsley and I represent the plaintiff, the Spider family.
This is O'Brien Martin. I represent defendant Kenneth Bradley Williams.
This is Kenneth Moss. I represent Charles Weldon Boyd.
Okay,
Robert Lee, I represent, Mr. Martin, same defendant.
with that, the court reporter will now administer the oath.
Would you raise your right hand, please? Do you swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Dr. Martin.
Good afternoon.
Would you tell the court what it is that you do for a living?
I'm employed as a professor of electrical and computer engineering at Montana State University.
And how long have you been employed here?
I've been at this university since 2002, so I'm starting my 24th year here.
And for the jury's benefit or the court's benefit, where are we today?
We're in Bozeman, Montana, on the campus of the university.
And tell us what that means. What is it that you teach?
The field of electrical engineering is a well-known specialty that deals with anything that has electricity involved in it. So that could be electrical power systems, could be computers, could be mobile phones. My particular specialty area is audio engineering, which is using electronics to record and process and interpret audio.
Okay. And if you could, give us a rundown of your educational background, beginning with college.
I went to college as an undergraduate at Washington University in St. Louis. Graduated there with a bachelor's degree in electrical engineering in 1984. Then I pursued a master's degree in electrical engineering from the University of Wisconsin-Madison in 1985, and then earned a PhD in electrical engineering from the University of Illinois, Urbana-Champaign in 1989.
Do you have any private or obviously you're here today in the case of South Carolina, but do you do private or consulting business work in this area?
Yes. So I, in addition to my responsibilities to the university, I also, in my spare time and weekends and evenings, do consulting work in my areas of specialty.
You were asked by me to analyze a couple of audio recordings, correct?
That's correct.
And is that the kind of thing you do not in your professional endeavors, not just in an educational perspective, but also for third parties?
Yes. So my consulting practice, which is the auspices under which I'm here today, deals with interpreting audio forensic analysis of audio recordings and videos and other evidence of that type. I also teach this subject in the university, so I have students who are studying the principles of audio engineering, digital signal processing, and basic audio forensic analysis. But I'm appearing here doing this work that I do in my private practice.
And what is the name of that practice?
Simply, it's my name, just a sole proprietorship.
Okay. And obviously you're being paid for your time.
Yes. That's
how much are you being paid?
My agreement is an hourly fee of $250 an hour.
Okay. Have you offered sort of expert witness consulting work in the past?
Yes.
Have you been qualified as an expert in court matters?
Yes. I've had courtroom testimony and depositions conducted in several states.
And in what area of expertise were you qualified as an expert to give expert opinion?
In audio forensic analysis.
Have you, and is that the area or the field of study in which you intend to offer opinions today?
Yes, it is.
Okay. And have you written, I know Mr. Moss has got a stack of your papers, but so have you written any materials that are peer-reviewed materials on this subject?
Yes, as part of my professional career for 30 or 40 years now, I've published papers, which means scholarly works that are reviewed by peer scientists and then published in journals, meaning that they're read by people with similar background and interests. I also give presentations at professional meetings. I've been invited to do that for a variety of organizations, as well as submitted publications for that purpose. And I've written a textbook about audio forensic analysis that has been published and reviewed for this particular area of my expertise.
And when was that first published?
The date, (2018).
And are you a member of any of those professional societies or organizations that you referenced that maybe you've written some of these papers for?
Yes, I'm a member of IEEE, which is the Electrical Engineering International Professional Organization. I'm a fellow of the Audio Engineering Society, which is a specialty field of audio engineers. I'm a member of the Acoustical Society of America and the American Academy of Forensic Science, and also the American Engineering Education, American Society for Engineering Education, ASEE, sorry.
And you're a licensed professional engineer in the state of Montana?
Yes, I have a professional engineer's license in this state.
How long have you held that?
I could look up the exact date. I think it's since 2007, 2008, something like that.
At this time, I would offer Dr. Maher as an expert in the area of audio digital signal processing and audio forensics.
Okay.
So, touched on it already that you were sent some recordings by me. Can you tell us what you received? Let's just start with what you have.
Yes, so my recollection is you contacted me via email and you provided 3 audio recordings. So these were in digital form. And I have a report that describes the details of those if you'd like me to refer to the exact file names and so forth.
So, and if nobody has any objection, let's identify them from your report so that we're all on the same page. There are 3, on page 3 of your report, there are 3 recordings noted. The first one is starts with O_P. Okay. And that is the 911, you refer to that as the 911 call center recording. Is that fair?
Yes, my interpretation of that recording was it appears to be a recording made at 911 Emergency Dispatch Center. So it seems to be on the site of the 911 operator, and then we can hear voices on a telephone channel.
Okay. The next one, at least that you got there, it's the file that begins with 911_1, and that is what you refer to in your report as the mobile phone recording of that 911 call. Is that correct?
Yes, my interpretation was that was a recording made at the calling end of the conversation, and it has utterances that appear to be in a vehicle and also the voice of the 911 dispatcher.
And for purposes of your analysis that we're going to talk about, I think I represented to you that was a recording made by Weldon Boyd's phone. Did you assume that to be true?
That was my assumption, that this was a recording that was made at the time of the incident.
And then the third recording is something referenced, new recording, which was a portion of the mobile phone recording but slowed down. Did you use that at all?
I listened to it just out of curiosity, but because you had informed me that that was a processed recording that you had obtained, I did not refer to that recording in the work I did.
Okay. Help us understand your rationale and why you weren't interested in that recording.
Well, the principles of forensic audio analysis would be to rely totally on the audio information that's presented from the actual scene. Other information about the incident and modified audio may be interesting, but I avoid that because that might tend to bias my thinking or give me a indication of some particular aspect of the recording that I would not have come to on my own using the principles of audio forensic analysis.
Okay. And did the new recording, the portion that was altered, did it affect your decisions, opinions, conclusions that you're going to give us?
No, I did not rely on that at all.
Right. The 911 call, this is from the call center call. Are there certain limitations in terms of the way those recordings are made and as far as what is captured in the recording?
Yes. So the 911 call center, because they have lots and lots of recordings to make, they generally tend to use a relatively narrow bandwidth, meaning the quality of the recording is sufficient for speech intelligibility, but generally they don't make it high fidelity. So, for instance, that recording was sampled at 8,000 digital samples per second, which is adequate for voice communication, but it would be much lower than a high fidelity recording that might be at 44,100 samples per second. That would be like a compact disc quality, or 48,000 samples per second. So it's only 8,000 samples per second, so it's somewhat lower quality. I found the speech to be very intelligible in that recording, so there didn't seem to be a limitation. The other aspect of the limitation is that the 911 call center is communicating with a caller over the telephone network. And the digital telephone network, like from a cell phone, modern cell phone, uses a speech encoding algorithm in the phone. So in other words...
Yeah, I'm sorry, what does that mean?
So that means that the phone is trying to extract information that's useful to interpret speech. So the speech sounds that we have, the vowel sounds, the fricatives, and so forth, are trying to be conveyed. So generally that telephone channel has difficulty if sounds are presented that are not speech-like. So if there is a bang or a
gunshot,
for instance, typically the speech encoding algorithm does not recognize those sounds as being speech, and so they're often not included in the information conveyed to the call center.
Okay. Now, in your report, you outline, and I'm going to call them limitations. If you don't like that word, you can use something else. In terms of the cell phone recording, were there certain limitations in terms of how cell phones record, what format that file is in terms of analyzing the audio of that call?
So the cell phone recording that was provided here is a wider band recording, and by that I mean it has more samples, digital samples per second. So the call center recording I mentioned was 8,000 samples per second. The recording of the mobile phone was done at 44,100 samples per second. So we have
closer to your compact disc example.
Correct. However, the mobile phone recording is encoded in what's known as MP3, which is MPEG-1 layer 3, which is a particular perceptual encoding algorithm that is pretty commonly used in audio recording. What it does is it tries, the algorithm, the software that's performing that encoding, tries to determine what sounds in the recording would be perceived by a human listener and tries to maintain those. In other parts of the recording that wouldn't be perceived by a human listener, it leaves out. So we end up with a recording that to a human listener will sound very much like the original recording, but we have to be concerned in the forensic analysis because it has a data reduction that has taken place during that process.
And what does that mean?
It means that instead of having every single detail of the audio waveform that was presented to the microphone of the recording device, some of the information will be left out or will be distorted slightly. But the purpose of the algorithm is to do that in such a way that we can have smaller digital files. We don't need to store as many digital bits, but still have it sound to a human listener the same as the original.
And maybe from a more dumbed down, which is the only term and way in which I understand it, is the distortion or that limitation a function of the information overloading the speaker, or that's a different issue?
It has to do with the way the human hearing system works and our human perception works. There's a phenomenon known as masking, and that technical term masking means that when we listen to a complicated sound, let's say it was a musical piece with lots of different instruments playing, our ear and brain are only able to detect a certain level of the information that's being presented. And so some of the noisy portions of the signal or some of the portions of the spectrum, the frequency range that are relatively quiet, a human may not be able to perceive those. So the perceptual encoding algorithm is intended to try to mimic the way a human would hear the sound and only encode the portions that are of interest. So a typical CD quality recording would have over 1 million bits of information per second in that storage. An MP3 file typically would maybe only be 100,000 bits per second. So it may be compressed by a factor of 10 or something like that.
Ultimately, does that limitation affect the opinions you're going to give us or your conclusions that you're going to give us today?
In the case of the timing information and in the case of the interpretation of the intelligibility of the sound, it really doesn't have any impact.
Okay. And now, the two recordings, your report indicates the 911 call center is 10 minutes, 17.28 seconds. Did you listen to all of it?
Yes.
And the mobile phone recording, you indicate, was 8 minutes, 22.804 seconds. Did you listen to all of it?
I did, yeah.
Were you given any direction in terms of what portions of those 10-minute and 8-minute calls to focus on?
Yes. So after I had received the files from you and did an initial interpretation and then spoke with you about, I believe on the phone, about what your needs would be and what I would be able to interpret from these recordings, then you asked me two specific forensic questions that I could address.
All right. And if you will, let's talk about the two questions that you addressed.
So I've listed them here in the report on page 6.
I tell you what, just for the record, we'll mark your report as exhibit. I know, but it's going to get confusing. I'm going to mark it as the last exhibit for the record, and then so when we get to the end, once I've marked the figures and things, I'll mark that as the last exhibit. But go ahead, I'm sorry.
So the two questions I've listed here in the report, and would you like me to read them?
Well, yeah, I mean, you can just, the first I'd ask you whether you could discern or tell whether there were gunshots prior to what we refer to as the first audible gunshot in the recording.
Yes, so both of the questions pertain to what I refer to as the mobile phone recording. So this was the MP3 file that appeared to be recorded during the incident from the vehicle that was involved, where the call came from. And the first question had to do with whether there were any gunshots audible in that recording prior to the first obvious gunshot at 3 minutes, 33 seconds FET, or file elapsed time. So from the beginning of that recording, at 3 minutes and 33 seconds, there's what I consider to be a very obvious first gunshot. And so your question was whether there were any gunshots audible in the recording prior to that time.
Okay. And so tell us what you did to analyze the audio to come to a conclusion.
So the principles of forensic audio analysis involve three general steps. First step I refer to as critical listening, and that is just like it sounds. It means without any distractions, simply listening with my ears very carefully to the recording. And that often involves several different passes through the recording. One time typically listening for the obvious, what I would call foreground sounds, like speech utterances or loud sounds. Another pass through listening very carefully for what you might call background sounds. So these would be sounds that would be not the main conversation, but things in the background. So that's the first thing is critical listening. The second step is referred to as waveform analysis. And what this means is using a software tool to visually to look at the waveform of the recording. And by waveform, I mean when the acoustical pressure of sounds reaches the microphone creates an electrical signal that is an analog signal that is an analogy to the pressure disturbance in the air of the sound. And so that produces a graph. So it has an amplitude, y-axis, and then time on the horizontal axis. And by visually looking at that waveform, that provides a way of detecting when there are changes in the signal, how loud different sounds are proportionally, and other metrics like that. And then the third technique required in audio forensic analysis is referred to as spectrographic analysis. And that's looking at the spectrum, the frequency spectrum of the audio information. And the spectrogram is a special graph that has frequency on the vertical axis or the y-axis, time on the horizontal axis, and then uses typically color or intensity of the brightness of the pixels to indicate the amount of sound energy at a particular frequency at a particular point in time. And so the spectrogram is a well-known technique in electrical engineering that uses the short-time Fourier transform to display the frequency content of the signal.
So I'm going to mark as Plaintiff's Exhibit 1 the Figure 1 from your report, and ask you to. You just explained to us about the waveform analysis and the spectrographic analysis, and does that demonstrate or illustrate what you were talking about?
Yes. So Figure 1 has two of these representations together.
Will it be useful for you to point to the figure in this?
If that's helpful? Sure.
Okay. I'll just get the camera fixed real quick.
Am I okay standing here?
Yes, sir. If you can just zoom in just a smidge. Yeah. Okay.
So this is Figure 1 from the report. The upper portion of this picture, that it is a white indication on a dark background, that's what I'm referring to as the waveform analysis. So time is running along here. This is roughly 30 seconds or so from time 3:33 to 3:58 across horizontally, and the vertical dimension of the waveform plot is indicating how loud or how significant that sound energy was at that particular point in time. So this particular span has audible gunshots in it, and those can be seen as these vertical impulsive indications in the recording.
So ultimately, and we're going to talk about we've said audible, clearly discernible. Is it your opinion that all of these gunshots were fired within, assuming the cell phone is within Weldon Boyd's vehicle, within that vehicle? The ones that you have illustrated in Figure 1?
Yes. So again, based on the critical listening, so listening to this very carefully, based on the waveform analysis, observing the occurrence of these impulsive indications that correspond to those loud reports, and then also the lower portion of this figure, which is the spectrogram that I mentioned, which is showing low frequencies to high frequencies vertically, and then horizontally is the same time span as the waveform. And what we can see is when we have a very impulsive or sudden onset of a signal in the waveform, that corresponds to a vertical bright indication in the spectrogram, because an abrupt sound like that has energy at all different frequencies, but it's very short in time. So we get a vertical indication in the spectrogram. So your question about these 29 impulsive sounds I've attributed to be gunshots in this, all of them have very similar amplitude. They sound very similar, and the spectrographic analysis of each of them is very similar. And so my assumption was all of those 29 sounds would have been from firearms in the vehicle where the recording was made.
And when you say similar amplitude, does that relate somehow to volume?
Yes. So when I say amplitude, I mean this indication of the sound pressure. So that would be the loudness of the sound.
Okay. And ultimately, you identify in the entire gunshot sequence, if another phrase, but 29 clearly discernible gunshots.
Yes, so in this figure, I manually added with arrows and numbers, I added these by hand, the indications of where I hear and see in the different segments that there is an impulsive sound that I'm attributing to be gunshots. And if I count all those up in this span from 333 to 358, I count 29 of those.
Okay. If you want to sit back down. So let me ask you some questions just in terms of the way that the energy or the gunshots would be recorded. So if we assume a gun is fired from a static position, it's not really changed in orientation as it relates to the microphone, would you expect to see similar waveforms and spectrograms of those shots with one gun? Does that make sense?
I think so. So yes, if there is a single firearm with same ammunition loaded and no particular change in the acoustical surroundings, which would mean that the gun was pointed in the same direction, the microphone was not moving or changing, there are no other changes like that, then from one shot to the next there would be some differences. The exact amount of gunpowder in the casing and the casing's crimp strength and a variety of things. There will be some differences between that. But all in all, we expect that the sound would be very similar in amplitude that I mentioned, in spectrum, and listening to it with critical listening.
And if we had, let's say we had two guns that were substantially the same. I mean, maybe they're different colors, maybe they're slightly different ammunition, but the same caliber. If they were as substantially the same as we could get two guns, and I'm just hypothetically, and they are different distances from the microphone, would you expect to see different waveforms and spectrographic analysis or spectrograms in terms of how those sounds would be captured?
The general answer would be they would be similar in amplitude because the parameters are similar. But if they're in different locations, I would expect there would be some discernible difference between the report of those different firearms.
Let me ask you in a different way. So if we have, let's say we just have a cell phone, for instance, and it's on the console, and I shoot straight ahead through the driver's windshield, and then I turn 90 degrees and I shoot out the window, would those be recorded the same, or would they appear differently?
I would expect there would be a difference discernible in that circumstance. the sound emanating from the barrel of the gun is directional, so it matters what direction the gun is pointing. It's not so directional that we'd expect there to be a huge difference, but there is there would possibly be a difference in that situation.
Can you tell us what that sound is?
I don't hear anything. They're obviously doing some work on the building. I'm sorry about that.
Yeah, that's okay.
LeBron said,
Timing was impeccable. All right. So,
It's loud. You can really hear that.
let's go off for a second. Yeah.
Info off the record. The time is 1:26 p.m. Mountain Time. We are back on the record. The time is 1:28 p.m.
All right, so Doctor, we've got some construction going on that we're probably not going to be able to avoid, so we'll try to talk loud and maybe a little quicker. I've marked this as Exhibit 2, Figure 2 to your report. So the first step that you mentioned to us in terms of the way that you would conduct this analysis was the critical listening, and does Figure 2 illustrate some of the things that you noted when you were performing that step?
Yes, so the figure has indications that I added of my interpretation of the utterances during this segment prior to the first obvious audible gunshot. So this section that's shown in the figure is from about 3 minutes 19 seconds to 3 minutes 34 seconds, where the first audible gunshot, it was at about 33.9, I think, so that's visible over on the far right of this figure is where that first clearly audible gunshot is. And so this is the segment of 15 seconds or so prior to that first audible gunshot.
And so just so the court understands, what is represented as the first audible gunshot in Exhibit 2 corresponds with what you've identified as number 1 gunshot in Exhibit 1.
That's right, yes.
And this is the area where you primarily focused to see if there was a gunshot before the first audible gunshot.
Yes, so the audio forensic question was whether there are any gunshots audible in the mobile phone recording prior to that first obvious gunshot. So this is an example of the portion of the recording just prior to that first obvious shot.
Okay. And are there any indications to a reasonable degree of engineering certainty of a gunshot within the section of the audio recording that's illustrated here in Exhibit 2?
No. So a combination of the critical listening I mentioned, looking at the waveform analysis here, and also the spectrogram, I did not find any evidence that there was a gunshot prior to that first audible gunshot in the sequence.
And when you've consulted in other cases, are those generally criminal cases?
Often, yes.
And what sorts of issues are you addressing in those kinds of cases, the ones you've testified in or given opinions in?
Well, the work that I've been doing for the last 10 or 15 years has often focused on gunshot sounds. And so that's a particular area that there may be a question of who shot first. If there's an exchange or apparent exchange of gunfire, there might be a question about the timing, how long time elapsed between one event or maybe one utterance and some other portion of that signal. And occasionally there's a question about if there are multiple shots, what is the likely firearm type or characteristic of the gun.
And when you're performing the critical listening, you're paying attention, or are you also paying attention to what the people recorded are saying or doing?
Yes, although that wasn't brought up as a part of the audio forensic question, it was helpful to me to do that, to understand and be able to talk about where, when, or what order in which different things happened.
And in Exhibit 2, you actually typed in some of the words that you discerned from the audio recording, correct?
Yes, so this is my subjective interpretation of what was stated as a reference at the different points in that recording.
And what you, I mean, you can hear Weldon Boyd identify himself at the beginning of the recording, but as far as identifying Bradley Williams, did you assume that there were two speakers on that, or two people in that car? One was Weldon Boyd and one was Bradley Williams?
Yes, and there's no way I knew that from the recording itself. So I believe you told me the names or somehow referred to the two parties that were believed to be in the recording, and that's the information I've used here.
But as far as specific, each, like, this dude's got a gun, I didn't tell you that's Weldon Boyd, or hey, back up Weldon. We didn't have that kind of conversation.
I don't recall we ever talked that way.
Does what you've indicated in Exhibit 2, in terms of what you've attributed each of the defendants saying, does that fairly and accurately depict what you heard them say in those recordings?
Yes, again, that's my subjective interpretation. So.
And is there any indication in this section of the audio recording that the cell phone changes its location, meaning that it goes from somebody's ear to the floorboard, or that it seems to have moved in any way?
I think probably what you're asking is there some acoustical change that occurred during this interval? Well, because I don't know exactly how this recording was made. I don't know if it was a microphone in the phone or if it was a separate microphone of some kind or a headset. I don't know precisely what type of device made this recording. But to answer your question, no, I don't see any change in the acoustical aspect here that would indicate to me that there had been a change in position of the microphone.
Yeah, so in my earlier example, I asked you if there was a change in position of the orientation of the gun to the microphone. You would expect to see something like that. But if we move the microphone, it would achieve the same thing, correct?
Yes, we would expect that there would be some indication in the recording that the microphone position had changed.
And if the phone were, say, a normal talking position to being suddenly dropped on the floor, in the seat, dropped anywhere, would you expect there to be some indication either in the waveform or the spectrogram?
Yes, I would expect that would be noticeable in the recording.
And to a reasonable degree of engineering certainty, is that indicated, like the cell phone being dropped, for instance? That was a lot louder than maybe it would have been, but is there any indication of that?
No, I did not come to that conclusion about any other recording.
Okay. Ultimately, you have some opinions about the 29 audible shots, do you not? In terms of most probably which weapon fired, or how many weapons were firing those shots?
Yes, again, based on the forensic questions that you asked me, one was this, whether there were sounds of gunshots prior to the first obvious audible gunshot, and my conclusion was I couldn't detect any in that time interval in the recording. And the second question that you asked me would be whether there would be gunshots referred to in the background that could be from outside the cabin of the vehicle in which the mobile phone recording was made. So as I was addressing that, I was trying to interpret whether the 29 clearly audible shots, if there were any differences or any changes or any significant effects that would lead me to the conclusion that those came from outside the cabin of the vehicle where the recording was made. And so to answer your question, no, I did not find any indication that any of those 29 shots were from a location other than inside the vehicle.
Ultimately, you not only record the amplitude of the shots, we know where they are in relation to the entire recording and each other. Fair?
Yes.
And did you form any opinions as it related to which or how many weapons had fired the various 29 shots?
The result that I had and that I give in my report is that the first 17 shots, audible shots in the recording are sufficiently similar in amplitude, in my critical listening, and in the spectrographic analysis, and the pacing that I would come to the conclusion that all 17 of those shots likely came from a single firearm. The only question was between shots 7 and 8 in the sequence, the time difference between 7 and 8 is so short that was irregular. That didn't seem to be likely to have been a single semi-automatic gun making those two sounds so close together.
All right. If we can, I'd like for you to sort of briefly walk us through your comparison of the amplitude of the 17 shots, and then talk about the waveform analysis of why you come to the conclusion that those first 17 shots are most probably from the same weapon.
Would you like me to start with this figure?
Yeah, for the record, I'm going to mark that as Plans Exhibit number 3, which is Figure 3 from your report.
So this figure horizontally is showing time, minutes and seconds. Horizontally here, the vertical scale on this is the amplitude, or how loud the sound was, and I've indicated with numbers the same sequence that was applied to the earlier figures. So this 1 through 17 is the same 1 through 17 that would have been on
Exhibit 1.
The figure 1. The difference of what we're looking at here than what the prior plots were is that this is looking at what is referred to as the amplitude envelope. And RMS is an abbreviation for root mean squared, which means we take the original waveform, we mathematically square it, so we multiply each sample times itself, which gives us a squared and purely positive result. We take the mean, or the average, over a short interval, and then we take the square root of the result. So this is a mathematical computation. It's not something I invented. This is a standard way to look at this type of a waveform to get the comparison. So we end up with, instead of the pressure fluctuation, which is very rapid during this interval, we're looking kind of at the overall envelope, or the sound level during this interval. So each of these spike-like features would correspond to the bang sound or the muzzle blast of the firearm. So we can see them pretty easily here. They vary a little bit in amplitude. They're not all exactly the same, but they're largely in very much the same realm over this interval. Horizontally, we can measure the timing, or the time interval between each of the reports. And as I mentioned, the one that I can't really explain is between 7 and 8 that I've identified here. These occur very, very close together in time. And my experience with pulling a trigger of a semi-automatic gun would be, I don't think it's possible to give 2 pulls and have the mechanical mechanism produce those two so close together. So I don't have an explanation for that. I guess it's possible. One of the, I'm just conjecture, one of the sounds could be a bullet impacting, the front of the car, or it could be some kind of misfire from that gun, or it could be a second firearm took that shot right about the same time as this one. I don't have a good way of knowing which is which.
With the variance in the amplitude. I mean, we can go and look at the windshield, and there are various bullet holes. They're not, so the firearm is not completely static. Can that explain part of the variance that we're seeing there?
Yes, I've done research on, for a given box of ammunition, how much variability there might be from one cartridge to another, for instance, and then, as you mentioned, if the trajectory is varying. So these are not unexpected within the circumstances that I understand for this recording being made.
And to your point about 7 and 8, shot 7 and 8, and not being able to say precisely or exactly the way engineers like to be, but it's your opinion more probable than not, based on the analysis, and we're going to get to the waveform next, that those first 17 most probably came from the same weapon.
Yes, there's nothing about these with this caveat about 7 and 8 that I can see clearly that I could attribute one or more of these sounds to a different firearm.
Right. And would it be helpful to go to Exhibit 4, which is Figure 4 from your report now? So this is Figure 4, what we're marking as Exhibit 4. Tell us what we're seeing here.
So what I have done here is use the time waveform. So this is the signal that was recorded from the microphone and then run through the perceptual coder, the MP3 coder, and then this is being reconstructed from that. This undulation that we're seeing here corresponds to shot 1 that I identified, shot 2, shot 3, and so forth. And there are 17 of these indicating those 17 individual shots. And so I put them here as what you might call a lineup so we can visually compare what the waveforms look like for each of those audible shots.
So it just so it's clear, if we could go back, I'm not saying but if you go back and you look at Exhibit 1, and the top portion of that was what you call the pressure up and down and the waveform, this is a more focused version of each one of those 17 points. Is that fair?
Yes. So this, if you will, is a zoom. So we're instead of looking at 30 seconds, we're now down looking at a few hundred milliseconds, a few thousandths of a second. So we've zoomed in on just what's happening around the time of one of the shots. So all of these reports are in that Figure 1. It's just that we've zoomed out, so all we see is a little blip. So this is looking at more detail of each of those sounds.
And there on the left-hand column towards the bottom, that's where you see 2 and then 1 carries over. Is that shot 7 and 8?
So 1, 2, 3, 4, 5, 6. Yeah, so this is what I identified as shot 7, and that's the start of shot 8, which then I've repeated the whole thing right here. So those are the 7 and 8. What I take from this is listening to them, I'm not, with critical listening, able to distinguish anything about these shots that allows me to make a statement that I think that's a different firearm. So these are similar enough, and you can see visually when we compare them that to our eye, to our ear, and the spectrogram as well, there's nothing really different about these that would allow me to say that's a different firearm.
It is possible that a firearm can fire that fast, but you call it a misfire or a malfunction of the firearm.
So my expertise is the acoustics, and so somebody who knows about the particular firearm believed to have made this sound might be able to give you a mechanical reason for that. That's outside my area of expertise.
Okay. And then, at least in my mind, it makes sense to, if we were going to compare, and I know I'm jumping ahead, are you able to look at the waveform that is expressed among those 17, and I think you just said it, to a reasonable degree of engineering certainty, it appears these are all from the same firearm, same general orientation, with the microphone or the cell phone, whatever it is, being in a fairly static position.
Yes, so to critical listening, to my waveform observations, and then to the spectrographic analysis, or using the techniques of audio forensics, I don't have anything here that I'm able to scientifically say would lead me to the conclusion that these were different guns.
Okay. And I'm gonna just sort of spoiler alert, but when we look at the waveform for the next 12 shots, do you have an opinion to a reasonable degree of engineering certainty that the waveform that's expressed in these next shots came from a different firearm?
So using the similar approach of critical listening, the waveform analysis, and the spectrographic analysis, after this 17 shots, there are additional shots, 12 more, out to 29. And those other shots have distinguishing features that would lead me to the conclusion that those likely came from a different firearm.
Okay.
Do you want to look at those?
Sure, I want to look at those. You tell me the best way to do that.
Okay, so now I'm from the report showing figure 7, and figure 7 is for shots 18, 19, 20, and so forth after the first one. And so again, I'm showing a lineup or comparing the different waveforms zoomed into each of those shots. Listening to those shots, my critical listening indicated that they appear to be at a more rapid cadence, and by that I mean the time interval between the shots is faster than in the first shots. And I've got a table also that shows the measured timing information there. So that was one thing I noticed. The other is these have a slightly different sound quality to them. And looking at the waveforms here, what I'm noticing is at the onset of these shot sounds, there is something I guess I might call a W. There's a waveform indication that has a particular distinctive shape that we can see in these successive gunshot sounds.
And just for the record, you're pointing at shot 18 and 19 when you were indicating there, correct?
Yes.
Okay.
And the details of those waveforms, and to my ear, sounds different and looks different in the waveform than the earlier shots that had been identified 1 through 17.
Okay.
And so that would indicate to me that I'm discerning something that's different about this portion of the shots, and I think the question would be, well, what might account for these differences? And there's a variety of things. It could be different ammunition. It could be a different firearm. It could be the orientation entirely changed for a gun. Based on the circumstances and the timing here, and the fact that these had this different characteristic, my sense was that these 12 shots were from a different gun than from the first 17.
Okay. And are somewhere between the end of this first 17 and somewhere during this time period, shots 18 through 29, do you also detect reloading sounds?
I think, as I mentioned in the report, in addition to the loud, obvious gunshots, there's a variety of other background sounds that I cannot identify for certain what they are.
Okay.
But they could conceivably be spent cartridge ejection, or debris falling from a broken window, or there's a variety of things that they could be. But these were the interpretation of the gunshot sounds.
Fair enough. Well, why don't we talk about that now? You're welcome to have a seat. Okay, sort of the second question that I asked you. So the first question was to a reasonable degree of engineering certainty in the field of audio forensics analysis. Were there audible gunshots, or were there any gunshots prior to the first audible gunshots? And you've told us what your opinion is on that. And then the second one was whether or not there were any gunshots from outside the vehicle that were captured by the microphone. Now, I've changed it from the way you've represented in your report, but tell us whether you found things that could, and maybe if we make certain assumptions, like that there was in fact another weapon being fired, are you able to find artifacts or graphical representations of those noises or sounds?
So the order in which I did this was originally listening to the recording, looking at the waveforms, looking at the spectrograms, and that's how I identified the clearly audible gunshot sounds in the recording, the 27 of them that have been marked.
So why are you doing that? Just for the record?
29 of them, excuse me, the 29 that have been marked.
Okay, and just for the record, I marked, you referenced, and I think you showed us figure 7. I'm going to mark that as exhibit 5. Told you I would get it messed up. And then...
You want 7 and 5?
Yes, I'm sorry. I'm just going to skip all those tables, I think. And then this figure 8 is going to be exhibit 6, which is what you've got.
Yeah, you messed up.
I know. Sorry.
I'm sure I'll do the same.
Okay, so
I'm sorry, what did you say, Mr. Moore?
I said I'm sure I'll do the same.
Okay.
So, I'm sorry, I just wanted to clear that. So I interrupted you. Tell us what you did with respect to trying to see whether or not the microphone recorded any other gunshots.
So I think I mentioned earlier that the process of critical listening usually involves several passes. By that I mean listening to the recording several times. One of the times deliberately listening for the obvious, what I refer to as foreground sounds, which would include the utterances of the participants and the very clearly audible gunshots. And then another listen, which is trying to pay attention to the background sounds or the subtle baby voices or other types of sounds that would be not so prominent. And so it takes a little bit of concentration to try to separate in my mind what I'm hearing that's the background and what's the foreground. And then looking at the waveform analysis, similar type of thing would be done. So when I originally listened to the recording and identified clearly audible gunshots, I was not listening and did not come to the conclusion that there were any other gunshot sounds in the recording. Then when I got your second audio forensic question, I went back through to try to see, could there possibly be any subtle sounds in the recording that I might have missed in the first pass that I could say, well, these are gunshots based on the critical listening, the waveform analysis, and the spectrographic analysis. Ultimately, I was not able to be confident that there were any other audible recordings. However, to address your question, and I've indicated in figure 8 here, there were several sounds between the very loud audible shots that have a spectral characteristic, meaning low frequency energy, and an impulsive nature that I can't identify as being inside the vehicle where the shots were fired. And so that was my response, which is there's a possibility that, as I've indicated here with the yellow arrows, there were additional sounds that might be attributed to gunshots from outside the vehicle.
So if we assume that Scott Spivey fired his weapon from inside of his vehicle, somewhere during this point in time of the entire exchange, do you have an opinion because what I hear you saying is that I can't identify these points as gunshots in and of themselves, but there are things here that I also can't explain that could be gunshots. Fair?
Yes, I think that's the correct way to put it. So I'm not in a position to be able to say, I was not at the scene, I don't know the circumstances, so from your explanation, the other vehicle that was at the scene was 30 or 40 yards away, I think was the description. There was a statement that it's possible that, and maybe there's physical evidence that I would not know from the acoustics, that shots were fired from inside that vehicle. And so at that distance, inside the vehicle to inside this vehicle, these types of reports would not surprise me as being the sound of gunshots.
Right. And just so the judge is, or whoever's looking at this understands, what you're saying is you don't know about the things other than what is captured on this audio, like, for instance, that you can hear 3 different speakers. You hear these 29 clearly discernible shots. You hear other noises that are captured, but you don't know whether or not Scott Spivey fired his weapon from this recording. But if we assume he fired his weapon from his car, do you have an opinion to a reasonable degree of certainty that these points that you noted in Figure 8, which is Exhibit 6, with the yellow arrows, are most probably those gunshots?
I don't know if I'd say most probably. They could be accounted for as this distant firearm inside the cabin of another vehicle.
Okay.
So
assuming the things
would require information I don't have.
Okay, but assuming the information that the weapon was fired during that period of time, those points would could indicate those gunshots.
Yes.
All right. And the way that the gunshot itself moves, if the gun were outside of the vehicle, pointed at the microphone, the cell phone, would you expect the gunshot to be louder, of greater amplitude, than if it were inside the vehicle and pointed in various different directions?
Yes, with all of the hypothetical description you're describing, yes, I'd expect that if the firearm was discharged out in the open versus inside a vehicle, that there would be a difference in the amplitude.
Okay. So and then Exhibit 7, which is your Figure 9. The spoken words that you've attributed to Boyd and Williams in this Figure 9, which I'm marking as Exhibit 7, do they fairly inaccurately depict what is captured on the recording?
Yes, so these transcriptions, again, are my subjective interpretation about what is being said at those points. The identification of Boyd and Williams, again, is based on you telling me who the individuals are believed to be. There's no way I can know that from the recording itself.
Sure.
But those are, to the best of my listening, subjectively what the utterances were.
Okay. And so, in summary, do you have an opinion to a reasonable degree of engineering certainty that there are no gunshots recorded by either? We've really just talked about the cell phone audio, but by either the 911 recording or the cell phone recording prior to what we call the first audible shot at number 1 shot.
That's correct.
Right. And if we assume that Scott Spivey fired his weapon at some point, do you have an opinion that more likely than not, those yellow arrows indicated in Exhibit 6, which is Figure 8, could be explained by those gunshots?
Yes, that's the way I've described it.
And that would be your opinion?
That's correct.
And if Scott Spivey's weapon were closer to the cell phone, pointed at the cell phone, it would be louder than if it were inside of his truck or pointed some other direction.
Yeah, so again, from my experience with firearms, that would be the case. I don't know, again, the specific firearms here or the circumstances. But yes, I would expect if there were a firearm closer to the microphone out in the open, it would be louder than if it were being fired from the inside of the vehicle.
Sure. But if say Weldon Boyd, I mean, if Weldon Boyd's gun is pointed at the microphone versus the opposite direction of the microphone, would one be recorded louder than the other in terms of amplitude in the spectrogram or the waveform?
I would expect that, yes.
I think those are all the questions I have for you. Thank you. Oh, and I'm going to mark, can we mark that copy there that you have? Sure. That'll be Exhibit 8.
I'll have to go back through these and make sure I've got all this marked right.
Sure.
And
Judge, can we take we might have a technical difficulty. Can we just take 5 minutes?
In this trial, we don't have technical difficulties. Sure, we'll take a break.
Not a jackhammer, it's a different technical
All
difficulty.
right, let's take about 10 minutes.
time.
Be seated, please. All right, technical difficulties minimized.
Best of my ability, Your Honor. So what we're going to, just so you understand, we'll play their designations. It may take a brief second for us to get back into ours, and then we're just going to play the whole thing.
All right.
You cannot identify the sprinkler in this case for what your analysis is limited to. Which individual fired which shots in this case?
Objection. That's right.
Okay.
Okay. You did not review any physical evidence in the case before conducting your analysis?
No.
Since completing your analysis, have you either on your own or having been provided to you, reviewed any additional physical evidence, any evidence whatsoever in this case? The recording was made from inside of a 2022 white Dodge Ram 1500 TRX truck.
No.
Okay. Were you aware that that specific vehicle was equipped with ANC, or active noise cancellation system?
No.
Were you aware that that vehicle also featured acoustic glass and enhanced door seals specifically designed to reduce external noise entering the cabin?
No.
Were you aware that foam and dampening pads are used throughout that specific vehicle to further reduce noise and vibration levels?
No.
The vehicle was secure during the recording, and what I mean by that is there's nothing open. The doors are closed, the windows are closed, the sunroof's closed. It's a sealed cabin.
I did not know that, but again, nothing in the analysis of the acoustics would make that a surprise.
Okay. Would it have, given the fact that you were asked to analyze specifically, can we identify any gunshots coming from outside of the cabin? Does that matter to you at all? Is that an important piece of information to have? To some of those things that I've just listed?
I guess what I would say there is that I was asked about, in the second audio forensic question, whether there were any audible gunshots that could be attributed to being outside the cabin. And as you saw from my conclusion, I couldn't conclude that to be true. So possibly one of the explanations for that would be the acoustical properties of the vehicle. But again, that didn't enter into the report.
Right, and I guess that's sort of what I'm getting at, is that would these noise reduction features on that vehicle impact your ability to detect sounds originating outside of the cabin, such as a gunshot from some distance away?
I think, yes, a reasonable person, and I consider myself a reasonable person, would figure that would have an effect, yes.
Okay. Okay. So if you see where I'm getting at with this, we've got you were not then able, it's clear that Mr. Spivey fired his weapon at least 10, 11, possibly 12 times. Based on the evidence.
I don't know.
And I understand your answer, you don't know. I'm just saying the evidence is there's evidence there to indicate that. Yet you cannot identify a single gunshot on the recording that came from outside of the vehicle. Is that right?
That's correct.
Okay. So it's entirely possible, given the information I've just given you, that there were gunshots that were fired at the beginning of this recording, during the middle of it, at the end, at any point during this whole recording. It is entirely possible that there are gunshots being fired that you are not able to pick up, identify.
Yeah, I can't answer something I don't know. And so what I do know is that out of the audio recording, I'm able to identify 29 shots that are attributable to being in the vehicle where the recording was made.
And none from the outside.
Right.
So that it is possible, even if you believe it may be unlikely or not, that there could have been gunshots undetected in your analysis of the recording.
It is technically possible, yes.
Were to engage in the same three components of critical listening and waveform analysis and spectrographic analysis, and came to a different conclusion about that. Do you state necessarily that they're wrong, or do you think there might be some subjective component about what they critically hear and what you critically hear?
It's conceivable that different examiners would differ in their approach and maybe transcribe words differently or something like that. So if they're using the scientific principles that I described in my book and that I used in this case, I would be pretty confident that they would come to the same conclusions.
You did state in your report at one point, and I just wanted to ask you about it because I didn't quite understand it, but you said in your report that the occupant's speech or utterances did not indicate any gunfire prior to the identified in-cabin shots at 3:33.95. What exactly do you mean by that?
All I was wanting to get across is I didn't hear a statement of, ooh, he hit us, or ooh, there was a shot, or we've been, there's a hole in the windshield, or some statement like that. So that's all I was referring to there. I didn't encounter any utterance by the occupants that was indicative that there had been a gunshot.
Would you agree necessarily, though, that you have listened to the audio, though, and I'm assuming you listened to it like me over and over and over again. And you even wrote it on your report where it says, this dude's got a gun, he's got a fucking gun, followed by, back up, Weldon, back up, put it in here, back up. I mean, and you can tell that the inflection in the voices are rising. Would you agree with that?
I would, yeah.
Okay. So, wouldn't you agree with me that that audio right there before clearly the audible gunshots begin, while they're not saying bullet or gun or fired, would you not agree that those words indicate that some sort of event is occurring? That they are perceiving something at that point? You maybe don't know what, can't say what.
Yes, I think that is what I would say, yes.
Okay. Could the yelling and shouting inside of the cabin of that vehicle have interfered with your ability to accurately detect less prominent sound from outside the car?
It could have interfered.
And I think you may have answered this question already, but I'm going to ask it once again. Would the type of firearm have any bearing on your analysis being used and being able to detect something from outside of the cabin?
The type of firearm wouldn't change the analysis, but physically that could change the audibility or the sound level.
For example, if it was a supersonic weapon versus a subsonic, the rounds being fired, would that make a difference? I'm just generally asking in your line of work and analyzing gunshots, especially in given these particular circumstances. If a weapon is firing subsonic rounds or supersonic rounds, would that affect the detectability of gunshots at all?
It could conceivably affect it. The supersonic ammunition, the bullet itself, as it travels through the air, creates a shock wave that, under certain circumstances, can be detected on a microphone. So you could have a situation in which there would be a combination of the supersonic shockwave report and then the muzzle blast of the gun.
Okay. Have you ever analyzed or studied the accuracy of gunshot sound detection under these exact same or similar circumstances before?
Talking to engineers, it's always hard to say what exact means. So are you referring to
what I'm talking about is all of these factors that we've sort of talked about and that have been discussed. The fact that you've got somebody with a weapon that is 30 to 40 yards or 75 feet or more away inside of the closed cabin of a vehicle that is equipped with noise canceling or acoustic dampening technology. I mean, that's what these exact circumstances.
No.
Okay. Do you acknowledge, Doctor, that it is possible, even if you believe it may be unlikely or not, that there could have been gunshots undetected in your analysis of the recording?
It is technically possible, yes.
Doctor, I think Mr. Moss has covered just about everything else that I would ask you, so that would be all of my questions for you. Thank you so much.
Very brief. So, one of the last points Mr. Martin was making, this idea that there's critical listening. Is there an indication that somebody's being fired at? If you look at page 13 or figure 8, somebody says fuck during the middle of this sequence. That's the kind of thing you're talking about?
I've included that reference there because there's an audible factor in this particular section, and that was my subjective interpretation of what someone said.
Right. I mean, we know it's during a shooting sequence, but I mean, you don't hear any language like that or anything from them other than he's got a gun prior to the first audible gunshot, correct?
That's correct.
All right. And now, you complimented Mr. Moss on being a zealous advocate, and he is a zealous advocate, and he was giving you sort of a hard time on figure 1 page 5, where he had circled the number of gunshots that he found, the 11 gunshots he circled. Do you remember that? Maybe we need to see his.
Yes, I remember that.
All right. And for the record, because he didn't mark it, if he circled 11, 10 of those were after the first audible gunshot. You recall that? Maybe you need to see it again. You want to see it again? Here.
Yeah, if it's a question like that, I'll need to see.
Sure. And maybe we'll just mark that page if that's okay with you, Kenny, or a copy of that. We might mark that as, that'll be 9.
Yeah, and I'm real hesitant to.
No, I'm just asking.
Comment about circles on a printed page.
Oh, I understand, but the circles that he indicated that he saw, no, leave them with it. 10 of those are after the first audible gunshot, correct?
I'm sorry.
Yes.
All right. And what that figure is essentially a representation of, in summary fashion, of a lot of information that if we zoom in on, if we change the scale, we can see it better, can we not?
Yes.
I mean, that when you perform your acoustical analysis, you're not looking at a figure from a mile away. You're zooming in and trying to listen and see what you actually see. Correct?
That's how a forensic analyst will work.
That's right. And in fact, if you look on page 7 of your report, figure 2, which was exhibit 2, you see there we are more zoomed in on what's happening than we are in the figure that Mr. Moss circled, right?
Yes.
And the node in the waveform and then the line he says he sees in the spectrogram, you can't see the line in the spectrogram once we zoom in, say in figure 2, can you? I don't know that you can see it in figure 1. I'm just saying once we zoom in, there's no line in the spectrogram that would be indicative of a gunshot, in your opinion, is there, sir?
No.
And he talked with you a long time about reverberations and reflections and surfaces and the way that gunshot acoustics work. But aren't those things all reflected in the waveform that you get? In other words, I assume in the paper where you're doing an analysis of a shooting where the gun is moving and the shooters are moving and there are multiple shooters, we're going to end up with waveforms that are dramatically different from one another as opposed to what we marked as Exhibit 4.
The expectation would be if the circumstances change, the firearm's pointed in a different direction, the microphone moves, a different firearm is discharged, all of those changes would be expected to be reflected in the recording. So those differences would be discernible.
So the wave is going to look different.
Correct.
All right. And in fact, in your introduction, you talk about the way that the acoustic energy is expelled in all directions, but primarily the direction the barrel's pointed. And that energy reflects and hits and makes its way to whatever device captures the recording. Fair?
Yes.
And so and you say that, it is inevitable that the mixture of sound due to the direct sound of the firearm alone and overlapping acoustic reflections and reverberation creates a complicated pattern. That's what's represented in Exhibit 4, is it not?
Yes.
The complicated pattern that has been captured by this microphone.
Yes.
And whatever its limitations are, that's what we have.
That's right.
And that pattern, if we had multiple firearms in different orientations that are dramatically different from shot 1 to shot 29, we would see a variation of those patterns.
That would be my expectation, is that those physical changes would be reflected in the recording.
But if you have one firearm, it's in generally the same orientation to the microphone, The acoustical surroundings, meaning inside the cab of this truck, aren't changing, and its relative location to the microphone isn't changing. Is it your expectation, to a reasonable degree of engineering certainty, that you will end up with waveforms that are substantially similar?
That will be the expectation.
And is that what we have in Exhibit 4?
Yes.
Okay. My last question, I hope, is, I think earlier I misspoke, on page 10 of your report, I'm sorry, it's not page 9 of your report, I think that that I had attributed the remaining 12 shots, but actually shots 18 through 24, not 18 through 29. It's your opinion those shots came from a different firearm than what we see in Exhibit.
Yes.
Yeah, which I'm trying to remember. I think it's maybe one. The first 17.
Yes, the change in cadence in the different audible character and the different waveforms I was detecting started at shot 18.
And it's your opinion, to a reasonable degree of certainty, that 18 through 24 is most probably a different firearm than 1 through 17.
Yes, that was the conclusion I came to, is the waveforms, the acoustical character, and the spectral character were different for those shots than the first ones.
Your Honor, the only other thing I think I want to do is, we have an SD drive. I know that we have provided you with a link to all the videos and all the recordings. We're going to have that SD drive, which has all those recordings, put it into the record, for whatever it may be worth, and I think that's it.
I spoke to somebody on this side, and it seemed like they had a thumb drive of some type that had all the exhibits on them, or something similar, maybe all the audio recordings. So am I correct in
It's the
thinking?
same stuff we got, it's the same stuff he got, but we'll hand it, it's got our exhibit numbers on it, we referred to them, so.
But is that everything? And what he's speaking of is the same deal, everything?
Yeah, there's nothing different.
But there were two.
We don't think so. I don't know what he's got on there, but I don't think so. I mean, it is, the case.
Then only those one included will be the two things just added in the end.
And they could be on, Mr. Davis' slides be on there, although not maybe by numbers?
Yes.
So they're on there, but the numbers, they're not identified by numbers, we mark them.
Yes. Yes.
Yeah, Judge, what I'm saying is, just like in the Mr. Boyd's testimony, all the actual telephone calls, if at some point some other court wants to hear these calls that are cited in our brief, the actual calls are going to be here available in the court record. You've got access to them already through a link, and so that's what I'm talking about.
Fair
Yeah,
enough.
he's right. What I've got you does not include those recorded phone calls.
Okay. All right. Those will be supplemented. Last exhibit defense, last exhibit plaintiff, for purpose of this record.
Thanks.
Whatever those numbers are, Cynthia will tell us momentarily.
Yeah,
As long as she knows which number they are, we can find them.
this would be defendant 67 then.
It's going to be 70.
70,
It's
sorry.
going to be 70 to 70. And there's 24. So plaintiff is 24,
Plaintiff's 24,
defendant is 70.
70. Okay, so the thumb drive and the SD drive will be respectively 70 and 24.
Yes, Your Honor.
All right.
Thank you, Your Honor.
Very well. All right. Y'all have asked for brief summaries. I think 10 minutes each is enough. That's brief.
About 15, Judge.
Well,
We can't clear this up in 10 minutes.
my gut tells me to do what I want to do. So,
That'd be 5 then, right?
I'll take his other 5.
no, if I just do what I want to do, I'm not going to hear from y'all again.
Well, don't do that.
But I mean, as y'all know, the lawyers know, this has been a lengthy hearing for Stand Your Ground. It's been 4 days, and a full 4 days. It's not been downtime doing things you do during a jury trial. Things happen. But the end result is we're going to get probably 2 different orders, one for each party seeking immunity. And those have to be drafted up and eventually submitted to the court. And after those are done, then there's going to be motions to reconsider. So, I'd rather not have closing summaries because of all that follow-up. This is not like a criminal court where there's no motion to reconsider. Criminal civil court has motion to reconsider, which can adjust, correct, modify findings by the court or omitted issues the court didn't address.
I hear you, Judge, but I would ask you to give us, whether you call it 5, 10, 15 minutes, to say a word or two.
All right, I'm going to give in. Y'all are moving parties?
Yes, Your Honor.
Y'all go first.
We have agreed not to be duplicative, but our clients are a little bit differently situated.
They certainly are.
Your Honor, I want to talk about the elephant in the room, okay? This case is really about the phone calls because the evidence, the relevant, probative, reliable evidence, or what the witnesses said, and the way this case has come out, it's the best evidence because those witnesses had outside pressures and they've been influenced. There's no question Mr. McMurray's been influenced. We played his on-site interviews right behind his deposition, slightly different. Blaze Ward, no question. She said facts don't change, opinions do. Well, her opinion doesn't matter for the purposes of what the court has to do. The facts do. And she confirmed the facts. But let me say, the phone calls are the elephant in the room, and nobody in the courtroom, other than my client, said the out loud part. They're disgusting. My client said they were disgusting. A lot of us probably thought it, but he's the only one that said it. They are after a traumatic event. They are after a time when my client was in a harmed state. He certainly had a crash afterwards, which he explained to you. And I submit to you, while they're horrible, they're not relevant to this case. There's no admission in them. There's no intent expressed with them. There's no design expressed with them. And so I feel that we need to address that. And that really is where Morgan's client and my client, or Brian's client and my client differ. My client, of course, was driving. Their client was not driving. But the phone calls are why I think we're here. And I would ask you to be very cognizant of that, Your Honor. And as far as Maher goes, the witness we just heard from, very impressive engineer. He and I talked about both being engineers when I was there. They hired the right man for the job, but he didn't do the job. He didn't lab it. He didn't know what kind of firearms they had. He didn't know what kind of vehicles they have. He didn't know orientation. And ultimately, he said, I don't know, because he didn't hear the gunshots.
He said exactly that.
He said he don't know. And so I don't know that he adds anything to the court's consideration, but I will defer to Mr. Any time I have left, I will yield to Mr. Martin so he can talk about the evidence in the case to the extent he can.
Thank you, Judge. Please, the court.
Yes, sir.
Doesn't matter to you where we stand, though.
No, say where you've come from.
Okay. I am going to make this abbreviated. You'll be happy to hear. Okay. But there are some things that I do think are worth mentioning, and I would like for you to take with you when you leave the courtroom. First of all, there's a lot of uncontradicted and/or facts that are overwhelming, I believe. I don't think there's any question in this case that Mr. Spivey was at Boardwalk Billy's drinking. We knew his blood alcohol was what it was. He got on Highway 9 and he drove horribly. He started at Bell and Bell with Blaze Ward, pointing a gun. Elderly couple forced off the road, pointing a gun. Drives on up through until he does encounter Weldon Boyd's truck that Bradley is riding in with him. And I would note there was no 9-mile chase. For what that's worth, I've heard it so much I want to say it. No 9-mile chase. That chase, if you want to, and we'll call it a chase if that makes everybody feel better. But it was 5 miles or so, and actually probably 3, because what you had was the 3 or 4 miles before they ever saw each other. You had 3 or 4 miles, maybe 3 miles, where there was interaction between these two vehicles, and then a couple of miles where there was a following of Mr. Spivey's vehicle to Camp Swamp Road. Now, there's no question that the initial aggressor in this, and we're talking about self-defense, was Mr. Spivey. No question about that. Now, what the plaintiffs try to say is, well, or at least the way I read his brief, and the question is, well, he was withdrawing. He withdrew. The law on withdrawal is pretty clear too. And there was no withdrawal in this case. There was no communication of that fact. If I guess what the withdrawal would be, well, he sped away a certain distance, and then he turned on the Camp Swamp Road. But the law is there, and we've given you a more recent brief here recently, today as a matter of fact, that what he did is the case law would call is a bit more of just a cessation, but not a withdrawal, a temporary retreat. He sped away in Mark's brief, and he's a great lawyer. Mark's brief talks about the withdrawal and the reasonably calculated unlawful move that would take away one's right to self-defense. That's what he claims here, because then you're at fault in bringing on the difficulty. But in this case, I would say that that's exactly the opposite. First of all, never communicated his withdrawal. In fact, when he turned off the road, as they turned on, he stopped. He jumped out with a gun, abruptly, yelling, waving. That's not a withdrawal. If you want to talk about a move that's reasonably calculated to cause trouble, that's it. That's it. He's not scared. If he was scared, frightened, for any reason, he would not have stopped. Or at least it seems to me that that's a reasonable interpretation of what happened. He had been controlling this whole situation the whole day. As the old law on malice used to say, he was a guy who was devoid of social duty and fatally bent on mischief. And that's what happened. If you want to get down to why this happened, he caused it. His fault. He didn't withdraw. Not under the law of the state of South Carolina, and you can read that, and I'll leave it alone. Now, they say, well, when Mr. Boyd took off after him, followed him, pursued him, chased him, whatever you want to call it. That, well, when he did that, then he became the aggressor and somehow lost the ability to claim self-defense, because then he's at fault for bringing on the difficulty. That's not what happened. I do want to say, first time I saw this law was in this case. But the law in South Carolina is, common law that is, that from the earliest times, English common law has placed a duty on every person who saw another commit a felony to apprehend him or make outcry, calling the community to pursue and take him. This duty remains an important feature of Anglo-American law in the modern day. Any person who views a felony has a duty to arrest or to call others to his aid by seeking an officer of the peace. That's what Mr. Boyd, and to the extent he had any role in it, Mr. Williams did. You got the 911 call, listen to it. They wanted to shoot him. He gave them a reason and a right, most likely, to do it on the highway when he puts the gun out the window at him. So, in that case, and in the State versus Dickey is another case that I would encourage you to look at on that same idea, where it talks about whether you're doing the right thing or the wrong thing. That speeding, whatever the speed was, as Mr. Tinsley's brief says, the speeding, assault with a vehicle, reckless driving, is an unlawful act, and he says reasonably calculated to bring on an encounter. Thus, they lose their right to argue self-defense because they're at fault. Because he knows that's the only reasonable chance he's got. Because I'm going to talk about just briefly, just a second, what happened on Camp Swamp Road is a classic self-defense event. Whether you like it or don't like it, it is. It is. So that thought that, okay, somehow Weldon Boyd, by doing what the law says he ought to do, Mr. Tinsley is a really good civil lawyer, I'm told. This is my first time in court with him, and he's a good lawyer. But it says there's a duty. So, Mark, it got me to thinking, let's suppose that Mr. Spivey did travel on down that road, and he didn't stop, and nobody stopped him. Nobody tried to stop him. Nobody tried to call the police. He gets to the next intersection, does one of two things. Drunkenly runs through that intersection, kills 3 people. Or something that was at work with him that day finally snaps and he shoots somebody. Maybe under the law, common law duty, you could sue Weldon Boyd or another motorist for not doing anything. You got a duty to call somebody, a duty to do something. And here, so where are we in this world if you do that, and then all of a sudden this happens, and you ain't got a right to self-defense. You broke the law. What a horrible thing. They chased him for 9 miles, which ain't true, but give it to him. But that's foolishness. It's foolishness. Now, if you go on past that, the question would be, okay, did he take off after him just to kill him, just shoot him? That's it. I'm mad with him. I've had enough. I'm just going to take off and shoot him. Well, I would say to you, Judge, that again is not what happened. They called 911. They asked witnesses to stay at the scene. They were trying to get officers there. The dispatcher did tell him, okay, get us some information. That's what's all this about. So I'm going to lose my right to self-defense because I do that? Shouldn't have turned down the road. Well, why? What's unlawful about that? Nothing. Nothing's unlawful about that. And between State versus Dahl and State versus Dickey, the idea that they have no right to call the police and try to get somebody, this guy, is ridiculous. I feel it is. Now, you know, Abraham Lincoln, it said, would tell a story about a dog and his tail. He'd tell an audience, said, listen, if a dog has 4 legs and I call his tail a leg, how many legs has he got? They would reply 5. He'd say, no, 4. Calling his tail a leg don't make it one. And calling this a unlawful chase don't make it one. And calling it a act reasonably calculated to bring on this fatal encounter don't make it one. That's not what it is. Now, what happened here, when you get down to the roadway, I think all the evidence certainly points to the fact that Bradley Williams and Weldon didn't want an encounter. They wanted to keep an eye on. You heard Bradley say in the video, 911, back up Weldon, and the explanation that they didn't want an encounter, didn't want to get close to him. And then, but they get there, and when they make that turn on the Camp Swamp Road, he has stopped. He stopped. He's abrupt quickly. And he gets out with a gun. Not a white flag, not a surrender, not a withdrawal, but a continuation of a pattern of criminal conduct that started at Bell and Bell Blaze Ward. From the moment he jumps out with that gun in his hand in a hostile manner, it don't matter who shot first. It doesn't matter who shot first. State versus Hendricks, which I know you're familiar with over the years, and State versus Dickey and State versus Starnes all make it crystal clear that you don't have to wait for your adversary to get the drop on you before you defend yourself. Now, who in this room that had been in the place of Boyd and Williams would not have been scared for their life when they had witnessed what they witnessed on Highway 9? And then he stops abruptly, jumps out with a gun, a loaded gun. Not to mention a small arsenal in the back of that truck that he did not get around to firing. Okay? From that point on, that's self-defense. Of course, the testimony you've heard, and they're trying to refute it, is he did aim, point, shoot first. I believe that evidence is not only by a preponderance that that's what happened, it's more than that, but all we have to establish is that by a preponderance of the evidence. Now, the evidence you got is what Weldon said, what Bradley said, and of course somebody said, well, they're not telling the truth. They lied one time, so they lie every time. Well, you and I know that ain't right. And there's never been a murder case, criminal case in Horry County or all over South Carolina or probably anywhere in the nation that there hadn't been some sloppy police work and some things are missed and they don't pick up something they should and it doesn't take a photograph. Now, in this case, they're trying to say that he didn't fire first and that it was at least Weldon Boyd's intent from the beginning to murder him. And as proof of that, they say, well, there was only one shell casing in the roadway. Well, there was one. Nobody said he shot a dozen times, but there's one. Well, it might have fell out of the truck. Well, maybe. You know, maybe the South Carolina football team win the national championship next year. But there's a shell casing in the roadway. There's 10 in the 9, 10, 11 in the truck. Then they say, well, Mr. McMurray, he's going to save us here. He gave a statement And he tried to back up on it, and you got the deposition, but he got himself confused. But at the end of the day, you take all of his testimony and you take it together. What he says is, I'm coming down the road, black truck abruptly stops, guy gets out with a gun in his hand. So their witness, Mr. McMurrow, got a gun in his hand. Gun in his hand. And he's not walking towards Mr. Burrow, nor he's not walking over to the ditch to shoot a snake. He is going back towards that white truck, yelling something. No withdrawal here, looking for more trouble. Sadly, I say that sadly because this is a sad event. From what I can hear, see, learn, Mr. Spivey was a decent young man. These are decent young men. But on that day, for reasons satisfactory to himself, Mr. Spivey was he was in a bad way. He in a bad way. But McMurrow said, I come by, he jumped out, I see him, he's got it, he's got the gun in his hand. And I look up and he said he sees what he thought certainly was Mr. Boyd with a pistol over the dash. He drives on that 75 feet, 25 yards from Spivey to Weldon Boyd's truck, and it takes some period of time to do that. Is it 2 seconds, 5 seconds? I don't know. There's probably some expert somewhere to give you an opinion on that. But at any rate, there's a period of time, and he says that he drives by, and by the time he gets into what he sees of Mr. Spivey, from that point on, is through his rear view mirror. And he's trying to drive, and he's trying to look at Weldon Boyd, and he's trying to get his wife pushed down. He don't know what the hell happened, to tell you the truth, but he's trying. He called 911. He knows his social duty. And then he says at the end of the day, I don't know who shot first. And they're going to say, well, he said he heard all of a sudden all hell broke loose, bap, 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 to indicate somehow that means that Mr. Spivey did not shoot first. It don't mean that at all. That is no evidence that Mr. Spivey didn't shoot first. There's a shell casing in the roadway, indicative of one thing and one thing only, that it was shot outside the truck. I don't care whether it's by the tire or on the side of the road, but you got that gun up, you're twisting around, and there's a shell casing there. He shot. But I'll tell you again, Judge, he didn't have to shoot for this to be self-defense. When he got out brandishing that gun, it would take an idiot not to think that my life is at stake here with this guy with a gun angrily moving towards me. Either way, these two young men had a right to act. Well, let me take that back. Officers don't have the right to act on appearances, but I tell you that they do, because they saw the gun here. I agree with that. So that means then they don't have to wait for him to shoot first, because you don't have to let him shoot first, because then you may not be able to shoot back and you're dead. Doesn't take a brain surgeon to figure that out. Self-defense, self-preservation is an instinct that comes from the gut. You got it, I got it, everybody in this room's got it. The great buck on the hill, mightiest in the woods and the forest, if he hears the snap of a twig, he's gone. He's not going to let trouble get him first. So, multiple shots, no doubt, multiple shots. Whether it's 24 cases they found or 29 that the expert had, and I'll talk about him in just a second. You fire, you're taught you fire well until the danger is eliminated, diminished, no longer a problem. And you heard the testimony of both of them. I know particularly well Bradley Williams, because I questioned him, that Mr. Spivey was able to get back into the truck. He did continue to fire, and I'll say again, according to Angelina Phillips, it is strikingly strange The point of all places on his body where he hit is under his armpit, just to the back of it, so they can call it the back. But it's under his armpit, and it travels through his body, side to side. Consistent, according to the pathologist, and to you as a bright, reasonable man, that's consistent with, he came out, he did at some point in time get that gun up at these young men. He shot, they started shooting, and I don't know what he knew about what they had or didn't have, but I don't think he had any reason to know they had the guns they had, the firepower they had. But they start shooting, his arm is up, and he turned, I'm going to get back in this truck, and one of those bullets that catches him right through there. He had the gun up. The physical evidence is he had the gun up, pointed at them when he was shot. He did make it back to his vehicle, carried on the fight, emptied the magazine that he had, and sadly he died. Sadly. Expert's testimony here.
Don't worry about him.
Don't worry about that.
He didn't hear shots outside the truck. I got
Okay.
that.
All right. Judge, he started it. He never withdrew. They were doing nothing but trying to get help to get to him. If there was a lack of judgment in what they did, the law specifically says that that doesn't eliminate your right to self-defense and does not make you at fault in bringing on the difficulty. State versus Hendricks. It's all through there. And Hendricks tells you exactly what withdrawal takes. It's not what you got in this case. So I want to say, lastly, whatever kind of case they got here, there's one thing for sure. There's a marked difference between Bradley Williams and Weldon. And I'm representing Bradley. And I talked about the whole thing called Bradley, made Bradley part of it, and he did shoot. Okay, I don't know whether he's the one that actually shot the young man or not. But Bradley came down minding his own business. He was not driving. He was not speeding. He was not chasing, pursuing, following, or any of those things. He did not turn down Camp Swamp Road. He was not looking for trouble. He said, slow down, Weldon, on the roadway. And when they got to the scene, and you can hear it in their voice, Judge, you can hear it in their voice. They're scared when they turn down that road and they see him with that gun. And what does Bradley say? Back up, Weldon, back up, back up. They tried to retreat. No duty to retreat in this particular situation. But that's what was on their mind, not killing him. If they wanted to kill him, they'd have drove right up to him. Right up to him, took that pistol out the window and shot him. That's not what happened. They weren't looking for trouble. But I hate to say it, but Mr. Spivey apparently was. So, again, I appreciate your time. I tried to do it as quickly as I can. But obviously this is really important to a lot of people, and I don't want to not do the best I can for Mr. Bradley Williams. He's a fine young man. Thank you, Judge.
All right. Ms. Tinley, I want you to stay there. I've listened to this whole thing, this withdrawal or trying to get away from the thing. Driving over 115 miles an hour trying to get away sounds like a reasonable trying to withdraw. I don't know what else you could have done to get away from there. That's getting away, that's withdrawing. At least that's indicative of it to me, and it wasn't working. Anyway, this is an immunity hearing. Not a guilt or innocence, it's not a money thing, this is immunity. And this not in fault and bringing on the difficulty, that's tricky, but credibility is huge here. I'm evaluating credibility of what I heard. And preponderance is 50-50 plus a smidgen. Y'all got to get the smidgen more to meet the preponderance. I really question the credibility of Weldon Boyd. I find his testimony lacking credibility in many places. I'll give a few, for instance. I'm not going through them all, but a few. He called Mr. Strickland a deputy, but he wasn't looking for help. Called the lawyer looking for help. I get that. I called the chief deputy, but it wasn't looking for help. It's not credible. The differing descriptions of Spivey's behavior outside the truck. Compare McMorrow's description to these two's description, totally different. I don't know how you confuse those. Even if you're looking through your rearview mirror, you can see a big difference. And then whether you call it pursuit, following, I'm chasing, they know. Both guys in that truck know that the guy they're following at a rapid, trying to keep up, has got a gun. Stay back. He's acting like a fool. He was. Spivey was acting like a fool that day. No question about that. But foolish behavior don't require you to foolishly act yourself. And it seems that driving over 100 miles an hour trying to keep up with the guy with the gun is foolish. So the Spivey speeds, y'all got me 1 second intervals all the way down that road. And somehow the Boyd truck was able to maintain its closer proximity to give a pretty detailed description to 911 once he was giving a description to 911. Anyway, I find it incredible. And the testimony of Williams, still balancing that. He's got better credibility than Boyd. Phone calls Boyd made after the fact shows his, I don't know, trying to get his story straight maybe. Trying to get help. Trying to make certain that they're going to be free and clear of any responsibility, liability, responsibility, whatever the word you want. And he's certainly communicating to Mr. Williams to get help in that regard. So, here's what I want. I find that Mr. Boyd's request for immunity is denied. I'd like a proposed order to that effect. I'm still sitting on Williams. He didn't want to be there. He said, back up, slow down. He tried, but yet there he is. So he had no way of not following at 100 miles an hour and keeping up. I'm not certain how to sort that out. I'm going to study that one. So I'd like a proposed order from you and from whichever one of y'all, three of y'all, I don't care which one writes it, from the team. Proposed orders respectively, granting immunity, denying immunity. This one's, I want 2 orders from you, 1 order from you. And you know, y'all asked me several times, do I want to hear the 911 tape again? The last time I heard it, this is, I don't know exactly, but it wouldn't take much to convince me the last word's on there. Mr. Boyd was backing his truck up. He said, backing up, backing up, backing up, removing himself away from the truck at the scene. I don't know whether he did it or not. Nobody addressed that, but it sure is on that recording. Pretty incredible statements when he's excited, reporting what he's doing. But the last 3 things he said, backing up, backing up, backing up. And that was after Mr. Williams said, why did you have to keep doing this? Said at the end. I don't know whether they moved the truck or not. Well, it doesn't have an indication or an impact on my decision to deny immunity, but It certainly could be argued. All right, am I clear on my instructions?
Yes, Your Honor.
Yes.
Clear? Clear?
Yes, Your Honor.
Good deal. All right. Now, I want y'all's orders to be turned in the same day. I don't want y'all to read each other's and respond to it. Prepare your own orders.
How long to do that?
About 2 weeks. Today's a Friday, Friday in 2 weeks.
Yes, sir, Your Honor.
About noon?
Sir?
Noon, Friday, 2 weeks.
Yes, sir.
Perfect. I like it. Mr. Moss, you file all the orders, motions you need to, because I've ruled against you and I understand.
Very well.
You just, I know you know the rules very well. So, nobody's restricted. File the appropriate motions. All right.
Thank you, Your Honor.
Thank you, Your Honor.
That concludes our hearing. Yes. Proposed orders in Word to my law clerk's email so I can edit them if I need to. Don't send them in PDF because I hate that.
Yes, sir.